This video contains AI-generated visual and audio representations used solely for educational and illustrative purposes. The United States Supreme Court justices depicted in this video are generated by artificial intelligence. Filming, recording, or broadcasting inside the Supreme Court, including oral arguments in the justices' private conferences, is not permitted. Accordingly, no real footage, audio, or recordings of the court or its deliberations are used. The arguments, questions, and opinions presented are paraphrased and condensed to accurately convey the general legal positions and reasoning expressed in the case while remaining brief and accessible. The attorneys for the petitioner and respondent are fictional, generic characters created to summarize and present shortened versions of the parties' arguments. Any conversations among the justices during conference are entirely hypothetical. These discussions are not transcripts or reenactments of actual deliberations, but are designed to help viewers understand the justices' commonly recognized jurisprudential approaches and viewpoints based on their publicly available writings and opinions. This video does not constitute legal advice and should not be relied upon as such. It is intended for educational and informational purposes only.
Today, we're taking a close look at Baze v. Rees, a decision by the United States Supreme Court in 2008 regarding the Eighth Amendment's prohibition to cruel and unusual punishment. Kentucky, like many states, used lethal injection as its method of execution. Its protocol relied on a three-drug sequence. First, sodium thiopental, intended to render the inmate unconscious. Second, pancuronium bromide, which causes paralysis. And third, potassium chloride, which stops the heart. Two death row inmates, Ralph Baze and Thomas Bowling, challenged Kentucky's protocol. They did not argue that the death penalty itself was unconstitutional. Instead, they argued that the risk created by this three-drug method violated the Eighth Amendment. Their concern was that if the first drug failed to properly anesthetize the inmate, the second and third drugs would cause extreme pain while leaving the inmate unable to signal distress. The Supreme Court was asked to answer several key questions. Does Kentucky's lethal injection protocol create an unconstitutional risk of severe pain? And what standards should courts apply when evaluating Eighth Amendment challenges to methods of execution? In short, how serious must the risk be before the Constitution is violated?
We'll hear argument this morning in Baze versus Rees.
Mr. Chief Justice, and may it please the court. Kentucky's lethal injection protocol creates an unacceptable risk that an inmate will experience extreme pain during execution. If the first drug is improperly administered or fails to work, the inmate will be conscious but paralyzed while the final drug causes intense burning pain.
Counsel, are you arguing that any risk of pain is unconstitutional, or that this risk is different in kind?
Justice Ginsburg, we are arguing that this risk is substantial and unnecessary. Safer alternatives exist, such as a single-drug protocol that significantly reduce the likelihood of suffering.
But capital punishment itself was accepted at the founding. Are you asking us to constitutionalize the best practices of anesthesiology?
No, Justice Scalia. We are asking the court to recognize that when the state chooses a method that heightens the risk of severe pain without justification, it crosses the Eighth Amendment line.
What is the limiting principle? Many medical procedures carry some risk of pain or error.
The line is substantial risk. The Constitution does not require perfection, but it does require the state to avoid procedures that pose an objectively intolerable risk of serious harm.
Mr. Chief Justice, and may it please the court, Kentucky's protocol does not violate the Eighth Amendment. The procedures are carefully designed to ensure unconsciousness and are similar to those used by other states.
What if the safeguards fail? Does the Constitution tolerate that possibility?
Justice Breyer, the Constitution does not require the elimination of all risk. The Eighth Amendment prohibits punishments that are deliberately cruel, not those that carry speculative risks inherent in any human process.
If we accept the petitioner's argument, wouldn't that invite endless litigation over alternative methods?
Yes, Justice Alito. Any method could be challenged by proposing a different one. The Constitution does not require states to constantly redesign execution protocols to chase theoretical reductions in risk.
So your position is that the risk must be more than hypothetical?
Exactly, Mr. Chief Justice. There must be a demonstrated, substantial risk of serious harm, and that has not been shown here.
We are not being asked to abolish capital punishment. The question is whether this protocol poses a substantial risk of serious harm. Speculative or hypothetical risks are not enough.
I agree. The Eighth Amendment requires proof of a substantial risk, and challengers should identify a feasible alternative that significantly reduces that risk. If courts demand perfection, no execution method will survive. The Constitution does not require the avoidance of all pain. This challenge misunderstands the Eighth Amendment. Capital punishment itself was constitutionally accepted, and accidental pain does not make a method unconstitutional.
The inquiry should focus on intent. The state does not intend to cause pain here.
I remain concerned about systemic risks and whether our standards should evolve.
While I agree the protocol is constitutional, I continue to have grave doubts about the death penalty as a whole.
If safer alternatives are readily available, ignoring them raises serious constitutional concerns.
I believe the petitioners have identified a real and unacceptable risk.
To establish that a method of execution violates the Eighth Amendment, a condemned prisoner must show that the state's protocol creates a substantial risk of serious harm. The risk must be more than speculative, and the prisoner must identify a feasible, readily implemented alternative that would significantly reduce the risk of severe pain. Kentucky's lethal injection protocol does not create such a risk. The Constitution does not demand the elimination of all risk of pain in carrying out a lawful sentence of death.
This decision is a plurality opinion. That means no single opinion was joined by a majority of the justices. Instead, the controlling rule comes from the opinion that received the greatest agreement on the judgment. Here, Chief Justice Roberts' opinion joined in full by Justices Kennedy and Alito, and in part by Justices Scalia and Thomas, provides the governing standard. The court held three main things. First, an execution method violates the Eighth Amendment only if it poses a substantial risk of serious harm, not a merely hypothetical risk. Second, challengers must identify a feasible and readily available alternative that would significantly reduce that risk. Third, Kentucky's three-drug protocol satisfied constitutional requirements. Baze v. Rees set the modern framework for challenges to methods of execution. Nearly every later lethal injection case relies on the standard announced here. The case also illustrates how divided the court can be, even when it reaches the same result. And it shows how plurality opinions, though fractured, can still shape constitutional law for decades. That's Baze v. Rees, a case about constitutional limits, judicial standards, and how the Supreme Court defines cruelty in the administration of the law's most severe punishment.